Good morning and welcome to our top tips. I'm delighted to be joined by Avril, Daly and Orla this morning. And our topic this morning is HR in the new, HR in the new normal. And when we reflect on the new normal, all we have to do is look around our circumstances this morning. I am broadcasting from my kitchen table. Avril has the luxury of her spare bedroom. And Orla is very proud of the fact that she's broadcasting from her dining room, not her kitchen. This morning we're going to cover topics which we believe is the new topical issues. That's not to say that issues in relation to health and safety and government schemes are no longer relevant. There's lots of information on our website, and our previous webinars cover this, and feel free to log on to our websites and you will see these. We have taken questions from the audience today in advance, and some of the topics we're going to cover will cover these questions. If you have questions to ask us during our presentation or at the very end, please feel free to use the Q&A box, and I'll do my best to answer as many as possible at the very end. This morning we are also going to do a live poll. We have 3 questions, and once we answer the 3 questions, at the very end, we'll go through these and we'll compare them to the live poll that we did previously. 3 questions are all what we see as kind of the topical questions. So question number 1 is, in your opinion, what is the biggest challenge with large number of employees working from home? Is it performance management when working remotely, ensuring health and safety best practice for home office setup, contractual legal obligation in terms of employees working from home in different jurisdictions, and supporting managers to maintain the communication and morale. So I'll give everyone just a few seconds. You simply tick the box and we'll be able to see what people's perception is of working from home and the difficulties that arise. Question number 2 then. Hopefully will come up in a sec. Question number 2 is, when do you believe your workplace may reopen fully? And perhaps with the new measures that were announced yesterday for people in Dublin, we might have different views. But will it be October to December, January or March, April or after April 2021, or not in 2021 at all? And again, just a few seconds to simply tick a box and we'll see what the results is at the very end. The third and final question do you believe your organization will make redundancies in the next 6 months? And one of the topics we're going to discuss today is redundancies. And you never like to end on a negative, but I think this is probably one of the more interesting topics, one of the more pressing topics that we will see in the coming months. So the question is, do you believe your organization will make redundancies in the next 6 months? Yes or no? At the very end, we'll come back and we'll discuss. We have, at the moment now, we have over 250 participants that are joined. So we're going to have a good survey of what people's reaction are to these questions. With that, we are going to start on the various topics that we are going to discuss today. And we'll deal firstly with indefinite remote working, and Orla is going to deal with this. I think one of the topics that we're seeing come through is that, particularly with the likes of Twitter, who have announced that you can work from home definitely from anywhere. And also, I think the likes of Google have made very firm decisions that it will be June or July next year before people are being requested or maybe requested to return to work. So Orla, it leads to the obvious question that people will probably want to answer is that, can employees really work from anywhere?
Well, I think naturally this depends on the nature of the work. However, where an employee can effectively work provided they have a good internet connection, whether that's from the beach or from their front garden, well, then practically speaking, there is probably nothing to prevent them working anywhere. However, there are some considerations that employers need to take into account. So the first is going to be the local employment law requirements. So, for example, if you have an employee who's going to work from Spain for a prolonged period of time, whilst the Irish contract of employment will continue to be in place and will govern the relationship, the employee might also accrue employment law rights in Spain. And for the most part, that might be fine, but you could end up in a situation where the employee cherry picks which is the most beneficial employment law rights to them, more often than not when the relationship goes sour. So it's good to look at these things in advance to make sure everybody's on the same page. And it might even be the case that it's recommended that the employee signs a new contract of employment for the duration of time that they stay in the new home country, i.e. Spain in this instance, just to avoid any dual employment law rights accruing. The second consideration is tax. Now, I'm not going to pretend that I know anything about tax or obligations or liabilities, other than it's really complex and I think I pay too much of it. But you need to be mindful of the potential tax liability that might be incurred in the new home country. So again, Spain in this instance, where the employee is working there on a consistent basis. Finally, I think you may actually also have to look at visa or immigration law considerations if that is relevant for the specific employee. Now, for individuals who are in the EEA and are just EEA citizens and they're looking to remain in another EEA country, well then, no issue is going to arise. But if you have an individual who doesn't actually fall into that category and their entitlement to work in Ireland is conditional on them remaining in Ireland, well then leaving the country for a prolonged period of time might actually impact on that. So it is something to bear in mind.
I think that proves that there's just simply a lot more to it than being, I suppose, nice to the employee and allow them to relocate back closer to family. One of the other questions that has always come up, and it's probably more in focus now, is working hours. And I think if you could just explain briefly, how should an employer regulate an employee's working hours?
The answer is probably with a little bit of difficulty at the moment. Albeit I'm sure many of the employees, the erratic hours that they were working at the start of lockdown have probably eased a little bit since the reopening of the schools and the creches and the availability of childcare. However, regardless of where the employee is actually working from, the statutory obligations on an employer haven't actually changed. So there's still an obligation to record the employee's working time, and there's still an obligation on the employer to make sure that the employee takes adequate breaks. I'm sure you've all seen the media reports recently where they're talking about what's being referred to as the COVID burnout. So according to a recent survey by UL, the University of Limerick, 60% of employees are feeling more stressed. And according to a recent poll carried out by Irish Jobs, 40% of employees are saying they're working longer hours, and 21% say that they cannot switch off from work. So it's very clear that the professional and the personal are actually morphing into one in the home. And you can understand that, to be fair, particularly where employees are working what would otherwise have been in the pre-COVID world, their commute to and from work. But there is an exposure for employers here. So how do you deal with that? I think the best way to deal with that is going to be regular communication with employees. So employers need to emphasize to employees, and ideally in writing, whether that's by way of an email or a policy update, to take your rest breaks, take your lunch breaks, don't work excessive hours, step away from the computer, go for a walk, whatever the case may be. You also need to ensure that employees are actually recording their time and using your normal time recording facilities. So it's very difficult for any employer to defend a claim where they don't have records in the first instance. Having those records is one thing, you also need to monitor them. So the employer should be actively monitoring the time records to make sure that there are no breaches, or at least no consistent breaches. And if there are, you should address them immediately. Likewise, I think if a manager or whoever is being copied on late night correspondence from employees on a regular basis, well then you're technically on notice of breaches. So it's something that you have to deal with. We all accept that there are situations where there's going to be the emergency email that has to be sent out of hours, but that should be the exception and not the rule.
Okay. One of the things that I think we have seen is that prior to the kind of COVID-19 situation, a remote working policy was perhaps a very small part of a handbook because it applied to a very small population of the workforce and probably was 1 or 2 days a week. So it now begs the fundamental question is, should we have a remote working policy, and what should it contain?
My advice would be yes. I certainly think it's something that you should have in place now, particularly where we're seeing a more permanent move to working remotely, whether that is on a part-time or full-time basis. Some of the basic ingredients that I would recommend that you have in a policy include, firstly, make it clear that even in the COVID world, there is no right to work from home. It's a perk that the employer can offer. So you have to ensure that your policy has scope to refuse an application. For example, maybe you won't consider employees who are on probation, or those with performance concerns, or maybe those that have certain disciplinary sanctions, or those whose working environment may not actually lend itself to working from home, whether that is for health and safety reasons or confidentiality reasons. Or obviously you're going to have the roles whose employees, the role that the employee must be in the office for whatever reasons. So working from home is not an absolute right. Even if you do accept an individual's application to work from home, make sure you have the right to require the employee to actually attend the office, whether that's on a temporary or permanent basis. So perhaps for client meetings or team meetings or trainings or covering other employee absences, etc. And obviously make sure that the policy says that you're not going to pay the employee expenses incurred for that privilege. Ordinarily, we would have recommended a trial period just, for everybody to see how this is going to work. However, in the post-COVID world, maybe we've had that trial already, so it may not be as relevant for your organisation, but it is something to bear in mind nonetheless. The policy should also cover the health and safety aspects of the arrangement. Now, I'm not going to go into the health and safety aspects because that's something that we've dealt with in a previous webinar, but it is something that should be included in the policy. And then finally, something that is often overlooked is specifically setting out in the policy that all of the employees' other terms and conditions of employment remain in force. So this covers things like working hours, confidentiality, data privacy, recording working time, etc. So they're the things that we would include in the policy. On the flip side, actually, we've seen a lot of requests from employers looking to permanently have their employees, both new and existing, work from home. And whilst this is something that may technically be possible, I think it's important for employers to remember that not everybody has a home environment that's compatible with working from home, and not every person has a personality that is suitable to work from home. So forcing home working on people is not always a good idea either.
And then the final, this is one, a number of people kind of submitted questions along these lines is, how do I performance manage or discipline or hold a grievance for someone who works remotely?
Okay, just performance management, I suppose it is a little bit more difficult now that you don't have that interaction or that physical interaction with the individual. However, I do think the best tips would be maintain your usual performance management style. However, you probably should have more regular catch-ups over Zoom or telephone or Microsoft Teams, whatever it is you choose to communicate with, just to ensure that the employee engagement is maintained at all times. If you're regular feedback, whether that's good or bad, and be clear on the goals and priorities. If performance is dipping, well then address it immediately. Employers now need to be creative with the way in which they can support employees. So if necessary, it's probably going to be things like providing access to online training or podcasts or webinars, upskill and provide support wherever possible. In terms of a disciplinary, again, your policy isn't going to have changed. So you're still going to have to follow your disciplinary policy, whatever that sets out. Presumably, many of your face-to-face meetings will now be replaced with virtual meetings, and that's fine. But otherwise, the process is going to be very, very similar to before. There's still going to be an investigation, a disciplinary hearing, and an appeal if necessary. The employee has the right to be represented. They have the right to notice of the complaint. They have a right to a copy of the evidence, etc. So the process isn't really going to change significantly.
I think that's a good point, the last point, that for a lot of policies have not changed. I think we're probably all in a way missing the human element of the face-to-face interaction. Sorry, we're just having some slide issues here. Sorry, Avril, it's over to you now. There's a number of questions coming through at the moment, and we will try to answer as many questions as possible, but it would be helpful, particularly if we don't get to the questions at the end, when I see them, they come in as anonymous, but if you'd like to put in your name and your company as well, after the webinar, we can come back to your questions. So that might just help people get a response from questions, because they're good questions coming in there. Avril, we're going to go back start with you. And this is going to be a very important topic for a lot of people, because a lot of people believe now that the ultimate test of working from home has only started in September, since the schools have opened up. And anyone that I meet at the school gates all say it's great that the kids are back, but how long will it last for? And there's this expectation that at some stage, be it a school will close or a creche will close, and that you and your children will be locked in the house for, be it now it's a period of 10 days. So it begs the obvious question: if this happens, will this be deemed force majeure leave, or will it be deemed sick leave for the employee?
Okay, so to the force majeure leave question first, that's actually something we had a chat about recently, and we actually had different views on it. But I think the answer will depend on whether you're talking about a school or a creche closing, or a child being sent home from school because they have the virus or because they have symptoms of the virus. And my view is that if a school closes, it's not really a force majeure situation unless the child is actually unwell, because technically the definition of force majeure leave is where, for urgent family reasons, the immediate presence of the employee is indispensable owing to an injury or illness of a close family member. So if a school closes and a child is sent home, this doesn't squarely fall within the definition, and technically the employee wouldn't be entitled to take force majeure leave. But in reality, I think a lot of employers would allow their employees to take it as that leave, and they probably should where they can, you know, particularly on the first day of a closure where everything is happening very quickly and employees might need to get home urgently. Now, obviously, if a child has the virus or has symptoms of the virus, well, then they will be unwell, and the employee can take 3 days force majeure leave in a 12-month period, or 5 days leave in a 36-month period. And that leave is paid by the employer. But it is quite a limited amount of leave, so it's not really going to cover an employee whose child has to stay home for 10 days or more. And turning then to your question about sick leave, no, this would not be deemed sick leave unless the employee themselves is actually unwell.
Okay, so that kind of gets us over, if you want to call it, the initial hurdle when you get the phone call from school to please collect your child. But what happens then? We still have a block of maybe a 10-week, 10-day period, and this, depending on how many children you have, this could be a very difficult situation. So it lends itself to the next question: how do we cover off the balance of these 10-day period? So can you force your employee to take annual leave?
The short answer to that is yes, you can. Under our legislation, the Organisation of Working Time Act, you can ask an employee to take annual leave, bearing in mind the employee's family responsibilities and opportunities for rest and recreation throughout the year. But the catch is that technically you have to give 30 days notice before the leave. And of course, no one really has the benefit of that 30 days notice these days. So it would be a technical breach of the legislation if you give less than 30 days notice, but we are living in exceptional times, and I think the practicality of this request has probably changed a bit since we were first asked the question back in April or May, when most people had, you know, the majority of their annual leave entitlement left, and they still were hoping that they might get abroad to take an exotic holiday towards the end of the year. But obviously since then, you know, people have accepted that a staycation is all they're going to get. And so they have used up a lot of their annual leave entitlement, and they may not have many holidays left as we head into the last few months of the year. But what we would recommend is that, you know, you're as practical about it as you can be, and remember that the theme of the Organisation of Working Time Act is rest and relaxation. So, for example, you might need to make sure that employees have some days left to take over Christmas, perhaps.
So we kind of have a mixture there of kind of force majeure leave and annual leave, but then obviously as we head in towards the, as you pointed out there, Avril, the latter part of the year, people might have simply no leave, so that then we get to probably the more difficult side of this this situation, is that can you ask your employees then to simply take unpaid leave?
Yes, you know, you can come to an agreement with the employee that they take unpaid leave. There's no issue with that if you're happy to allow them. And I think I would just be clear about the terms of the leave and the duration of it. Okay.
And then we know there's different statutory leaves, but is it possible, or will some element of statutory leave be able to cover off this situation, particularly if it occurs more than once or twice in the next few months?
Yes, yeah, there are lots of different options for taking leave. And I think, you know, the thing is to be as reasonable as you can in the circumstances, you know, depending on the employee's circumstances. So we've looked at annual leave. Obviously, aside from that, some employees might look to start maternity leave early if they're pregnant, or something that's proving popular is to take parental leave, which is unpaid. And the parental leave entitlements actually increased 2 weeks ago with effect from the 1st of September. So eligible employees can now take 26 weeks parental leave, and that can be taken in 1 or 2 blocks, or even broken up into days or hours if the employer agrees. Aside from that, then, since last year, new parents are also entitled to 2 weeks parents leave, which is distinct from parental leave, and that has to be taken within a year of the child's birth or adoption. So that's another option. And where an employee does qualify for parents leave, they're eligible for state benefit for 2 weeks as long as they have enough PRSI contributions. And then there's actually talk of that entitlement being increased further after the budget in October. Now, something to remember with these statutory leaves is that there are technically notice requirements associated with them. So for both parental leave and parents leave, for example, an employee is technically required to give at least 6 weeks notice before taking the leave, but obviously that's unlikely to be practical. So, you know, these are nuances that will have to be considered when looking at leave requests. And I think that I think employers should try to be as flexible and accommodating as possible. The last thing I would say is that obviously if you can explore some kind of flexible working option with the employee, whereby they work shorter hours or maybe earlier in the morning or later at night, well, then that might be the best outcome for you and the employee, rather than having to look at leave. So, you know, the first port of call is always to sit down with the employee, or by Zoom, obviously, and chat about all reasonable and practical options.
Yeah, it's going to be it's going to be a very interesting time. I think we're all going to have to start praying that the fine weather continues for as long as possible, and there is no flu symptoms or anything like that in the next period. Orla, we're going to move on to what we've loosely deemed the reluctant and vulnerable employees. And it's interesting in that even before we got to this topic, we've had about 4 questions that have actually centered on this already. So we're either geniuses for picking it out as a topic, or it is actually simply. And we're going to discuss what Orla, Avril and I have discussed in advance is 3 scenarios. And we're trying to label them scenario 1, 2, and 3, but with 3 situations. So scenario 1 is an employee who's fit and healthy, but is just fearful of coming back to work. So that's employee number 1. Employee number 2 then is what we are calling a vulnerable employee, an employee who has an underlying condition and they are fearful to come back to work. And then employee number 3 is an employee who is fit and themselves have no underlying condition, but they live with or they have to look after, be it a child or their elderly parents. So they're indirectly associated with someone with a person. And all these individuals, we're taking it for this fact pattern, we're taking that they have to attend work as opposed to simply being able to work from home. So Orla, if we could deal with scenario number 1, which is the fit and healthy employee who is fearful of returning to work. So what's an employer's obligations to that person?
Okay, firstly, and I think you've actually kind of touched on it, but I think I'll just bear in mind that the current government advice, which was updated yesterday, is to continue to work from home if possible and only attend the office for essential on-site meetings, inductions or trainings. But as you said, for the purposes of these scenarios, we're going to assume that working from home isn't possible. The fearful employee, as you said, is where there's no medical vulnerability, but the individual is just super cautious and genuinely fearful of, let's say in this instance, using public transport, regardless of anyone's compliance with the COVID restrictions. In that scenario, I think first of all, you have to engage with the employee and see if you can address their concerns directly. Explain obviously that you're complying with all of the guidelines and the restrictions that the government have put in place and see where that gets you. In this instance, it might be worthwhile or possible to see if you can actually maybe, change their working hours so that they're not actually coming to work during peak times, so they're not on the public transport at peak times. And also, dependent on your situation, there may be more car parking spaces available because you might have less people in the office. But assuming that you've exhausted all reasonable measures, I think you can take a robust response with the employee and require that they attend work as per their contract of employment, or otherwise there's no entitlement to be paid.
Okay. Yeah, I it's great. People have to attend place of work. The second scenario then is the employee who is fit for work, but then, he's not fit for work, is a vulnerable employee who does not want to return to work. And what are your obligations to this individual?
Okay, so the HSE has two categories of risk, those that are extremely vulnerable and those that are high risk. And the distinction between the two is primarily based on the individual's health and their age. The current advice for extremely vulnerable workers, if they can't work from home, is to get advice from their occupational health advisor, and obviously the employer is going to follow that. If you're a high-risk employee, and obviously you can't work from home, you are permitted to attend work, but you have to keep at least 2 meters apart from the other individuals whilst you're at work. Now, vulnerability in the context of COVID and disability in the context of our employment legislation under the Employment Equality Acts are likely to overlap considerably. So it is important to bear in mind that under our legislation, employers have a statutory duty towards employees who have a disability, so that you have to actively engage with them to see what measures you can take in order to ensure they can continue to work. And if those measures include, taking on alternative duties so that they can work from home, changing working hours, etc., I think that is something that an employer would at least be expected to consider. Ultimately, how you deal with the vulnerable employee is going to depend on the medical evidence. You should engage with the employee to see if you can address their concerns. However, if the employee has a medical certificate confirming the medical condition and also confirming that they should not attend the office, well, then the employee's absence is going to be considered sick leave and it'll be managed in the normal course. If, however, there's no medical recommendation that the employee does not attend the office and you can just simply follow government guidance, well, then the employer, I think, is well within their rights to require the employee to work from the office or otherwise run the risk of not being paid.
And the third scenario then is a person who is fit themselves, but they're not fit, or they're associated with someone who's be it elderly or their child. What's the situation in relation to this person?
Again, I think we have to look at our employment equality legislation here, which prohibits discrimination in relation to somebody on the basis they're associated with somebody who falls within the 9 grounds. So it is something that we don't come across too often, but it is something that might actually apply here. So again, the first protocol is to engage with the employee and to see if there are any reasonable measures that you can introduce to reduce the risk. Assuming that the risk can't be managed either through engagement or through reasonable measures, then I think you can say to the employee, look, you're either coming to work or else you're going to be at home and it's unpaid leave.
Okay. Very interesting situations. I think there's situations we're going to see a lot more, and we can see from the questions, or I can see from the questions coming in, where people have already had experience of the doctor's certificate being submitted to the employer, where a person has been deemed vulnerable and unable to work. We're going to move on to Avril to restructuring. And I think one of the things that kind of happened, in my opinion, is that given the speed of the lockdown measures in March and April, I think layoff and short time was the kind of the crude tool of how people went around kind of fixing. They didn't have time to do or consider restructuring. And then the governments subsidized or supplemented this kind of position by the various schemes that are in place. But I think what we're seeing now is that people see a visibility of what their workplace is going to look like. You can see from the government's levels, I think it's only level 5, which is kind of similar to the previous lockdown. So we're a little bit off that. But leads, I think, to more and more redundancies being considered. And I think a question that has come up quite often is that where you have people who are laid off and put on short time, be it in March, or even could still be laid off for in short time, are these people automatically in line for redundancy, or should some other mechanism be considered?
I think, you know, just because you have a group of people who are laid off, that does not automatically mean that they have been lawfully or correctly selected for redundancy, because as you said, most layoffs happened very quickly when the country shut down very quickly. So I think there is a process that should be gone through, which is gathering up all the staff that are doing similar jobs and carrying out a selection exercise with all of those employees rather than just those who are on layoff. But as well as that, we need to be mindful that the selection issues and the problems that have always existed for redundancies, you know, such as people on sick leave or maternity leave, those issues could be intensified now when you consider vulnerable people these days. So for example, those with an underlying illness, or even older people who are more at risk when it comes to COVID-19. And you don't want to be seen to be simply selecting those people because they're less likely to come back to the office. So, you know, the fundamental thing is that redundancy and the redundancy process has not changed. And I would suggest that you restart the process, particularly with any layoffs that were just intended to be for the short term.
Okay. And I suppose we've had a huge, over 1 million people this calendar year will have received some sort of payment from the state. And therefore their salaries and their weekly wage has gone up or down. So it leads to a question that's going to become quite common, is that what salary is actually used for this, or what weekly wage is used for this person when you're calculating their redundancy?
Okay, first of all, I think it's worth mentioning that the current rules in relation to the suspension of an employee claiming redundancy, those rules were extended yesterday until the end of November. And they could be extended beyond that. So normally the rule is that if an employee is laid off or put in short time hours, they can claim redundancy from you after 4 weeks, 4 consecutive weeks or more, or 6 weeks in the previous 13 weeks. But the current position is that if an employee was put on layoff for a short time because of COVID-19, well, then they can't claim redundancy from you. Now that rule could be done away with at some point in the future, and employees may then have the right to claim a redundancy payment. But remember that that's from an employee's side. So, you know, an employer can still decide to implement redundancies now if they want. And in terms of what salary you use for calculating the redundancy payment, it'll depend on the nature of the circumstances. So if you make an employee redundant within 1 year of putting them on reduced hours or reduced pay, their redundancy payment will be based on their earnings for a full week. If they're made redundant after working reduced hours for more than a year, how their payment is calculated will depend on whether they actually accepted being put on reduced hours or not. And that's a rule I'm not sure is entirely fair now. It didn't necessarily envisage a scenario like COVID-19 when lots of people just had no choice but to accept being put on reduced hours. So we'll have to see how that pans out. Aside from that then, if you opt to make an employee redundant after a period of layoff, which is obviously going to be quite common, their salary for the purposes of redundancy payment will be their normal weekly remuneration before they were laid off. Likewise, if an employee has been getting payment under the TWSS or the EWSS, it looks like their normal pay before they were put on the scheme will be used for the purposes of calculating their statutory redundancy entitlement.
Okay, that's very, very clear. This question has two polar opposites. So we have question number one is where an employer has actually money, but its business is reducing. And question number two is probably trending towards, sorry, not trending, but it actually is an insolvency situation. So we've seen a lot of this in the last number of weeks, particularly as redundancies come into focus. So employers down through the years have offered various packages, you know, visits, 3 weeks per year service, 4 weeks. And I think during that times, we've seen during boom times, we've seen up to 8 weeks per year service. But the question that's being actually asked now is something, the opposite one is that, can I reduce the ex gratia payment, be it from 4 to 3 weeks, or in fact, perhaps even eliminate it entirely?
Okay, well, I think that the short answer is yes, you can, but obviously there may be some risk involved. A lot of you might have seen in the Debenhams case recently that the employees have been campaigning for 4 weeks pay per year of service because that was what was agreed in an earlier collective agreement in 2016. But the liquidators are insisting that that agreement doesn't have any standing now that the company is in liquidation, which means that the employees are only going to get their statutory entitlements, which of course is 2 weeks pay per year of service plus a bonus week, and that's capped at €600 per week. The Taoiseach said that he considered the offer. Neil Varadkar, on the other hand, was saying, look, you know, even though it might be unfair to pay the employees, anything else would be beyond the law, particularly where it's an insolvency, and the government is already stepping in to make sure that the employees get their statutory entitlements. But if you have a consistent practice in your organisation of paying, for example, 4 weeks pay per year of service in a redundancy situation, employees could argue that they have a contractual right to that package, because even where there's no written entitlement to a package or a formula, it could be deemed contractual by virtue of custom and practice. And in theory, then the formula can only be legally changed with the employee's express consent. But in reality, you know, I think the risk of changing the formula is, particularly in the current climate, relatively low. And we have seen plenty of employers simply pay a lower ex gratia sum than they have traditionally paid. I think that employees are realizing that if they get some kind of ex gratia payment in the current climate, it's quite a good position to be in. Now, having said that, we're yet to see how claims will be dealt with.
Yeah. And this is one of the, I think it's probably one of the most frequently asked questions amongst the team, the ex gratia payments. But then we go on to probably, which I suppose the unfortunate situation where your employer is now, there's no such thing as an ex gratia, your employer's gone insolvent, and the employees simply looking for their statutory redundancy payment. So can you briefly explain the mechanism that operates in that situation?
Yes, so there is a scheme in place called the Redundancy Payment Scheme, which is there to ensure that employees get their statutory redundancy entitlement when they lose their job if their employer can't pay them because of financial difficulties or insolvency, like in the Debenhams case that I mentioned. And these redundancy payments are paid from the Social Insurance Fund, and they're based on the employee's statutory entitlements. And actually, there were recent reports in the media showing that applications to the Department of Employment Affairs and Social Protection for access to that scheme have hit over 660. So I think that's the highest level since monthly records became available in early 2016. So, you know, we are seeing that employees are having to avail of the scheme.
Right, and I think maybe those records will be perhaps maybe tested or maybe broken as we go forward. The last topic, Avril, for yourselves today is just for people that have hearings and or have potential claims. Just very briefly, what's the position in relation to these hearings? Are hearings ongoing, or how are they operating?
So yes, hearings in general are running again. And to be honest, we're still kind of coming to grips ourselves with the new format of hearings in the WRC and the Labour Court. From mid-August, I think it was, some face-to-face hearings have been offered, but the backlog is slow to make up for the lack of hearings during lockdown. And I know a couple of people on the team, including you, Ger, have had physical hearings in the last few weeks. Since mid-July then, the WRC has been holding virtual hearings for those complaints that are suitable. And the Labour Court has been doing the same for virtual hearings since June, I believe. And I think, you know, initially the kind of cases that are being targeted for virtual hearings are complaints around working time, pay and industrial relations issues more than, you know, the UD or unfair dismissal cases. I know, Ger, you had a virtual hearing recently and your biggest question was, what do I wear? Do I need to wear a suit and tie? And that might sound funny, but you know, these are the things that we are having to learn as we go along, not to mention with grappling with technical issues, you know, as we log into a Zoom hearing. And I think, you know, the WRC and the Labour Court are conscious of that, and it's a bit of trial and error for everyone involved. I know that the Labour Court, for example, are suggesting that everybody logs onto the hearing 15 minutes early to make sure that everybody can hear things and that their mics are working. And aside from that, then the normal timeframes will still apply for sending in submissions and written statements. Other than that, mediation is still offered by telephone, although I think Orla has a physical one coming up, but that's relatively unusual. And the WRC will look at reviewing certain complaints by written procedure for claims that are suitable.
And then I think we've seen one or two people, people still value, if you want to call it, the face-to-face and don't believe perhaps they'll get the best hearing possible through a virtual or a written procedure. So can an employer and employer simply object to it? And is there any penalty for the objection?
Yes, yeah, they can object. And I have seen employees say, no, I want a face-to-face hearing, which is fine, but it does mean that they'll have to wait longer for their complaint to be heard. Likewise, you can object to a hearing being done by written submission if you don't feel it's appropriate, in which case it will go forward for a hearing either virtually or in person.
Okay. Yeah, I think so. For anyone that has a claim that the claim is going, but the claim would have to be open and honest and say the claims are proceeding slowly, and it's certainly claims which are even in existence and are, you know, half heard, they're being ticked off extremely slowly, and it's probably going to be 2020, certainly if a claim is filed now, 2021 or mid 2021 is before you're going to deal with. And my thanks to Orla and Avril. We have had a huge amount of questions, which we'll try to cover in a second, but I think we're just going to have a look at the poll results of the 3 questions. And the first question was, in your opinion, what is the biggest challenge with large number of employees working from home? And you'll actually see is communication and morale is actually has taken the lead there. So it's interesting in that we have probably all lacking in a way the human elements. Performance management is, and you wonder, is there a link between them where you don't have, or where it's difficulty to maintain a team environment and communication? Does this lead to performance issues? So that's quite an interesting response. Question number 2 then, which is the question to do with here comes the results. When do you believe you may be fully working from, or your office will reopen? And it says after April 2021. And it's interesting because when we asked the same question in May at the last webinar, 78% of people felt that they were going to be back in the office within a 2-month period. So majority of people felt it was August. And would you believe it, only 2% felt it would be 2021. So now the 2% has converted into 63%. And maybe it's probably, and 1 person or 5 people or 7 people or 5% believe not in 2021 at all. I didn't put in the option of not in 2022 because it would have been just simply too far, but it's interesting that our perception has moved on slightly. The final question was to do with redundancies. Do you believe that your organization will be making redundancies in the next 6 months? And you can see nearly 40% said they were going to. So we can see how, and to Avril's point, how we've seen now redundancies have become certainly much more front and center, and layoff and short term are probably being less and less likely. We only have a few minutes for questions. I thank everyone for submitting the questions. We have over 21 questions that we have to deal with, and we will afterwards, as a team, will come to, we can come back to the questions. But I suppose 2 questions have been submitted. I will go with one for you first, Orla, is, and it's kind of it's a direct question, but it's also a trend that within the questions is, can I change my sick leave policy, particularly where I think I'm going to have large number of people that may not be able to come to the office or maybe out? So where someone has a nice sick pay policy, can I be Cruella de Vil and change it?
I think the answer is probably possibly, but it first of all depends on where your sick leave entitlement sits. So if you have a sick leave entitlement that's, you know, set out in the employee's contract of employment and it's very definite and, you know, you're entitled to 26 weeks sick pay, well, naturally it's going to be far riskier to reduce this entitlement than where the contract of employment might refer to a separate sick pay policy, which, you know, doesn't form part of the employee's terms and conditions of employment. So if you have a situation where the sick pay entitlement sits in a separate policy, and that policy contains your standard wording in relation to discretion and variation, etc., well, then I think with reasonable notice, the employer can vary that entitlement to sick pay. I would probably, however, caution that it should apply prospectively as opposed to retrospectively. And then depending on the change, you're probably best, if you don't want to take any risk, is likely to only apply to it to employees that aren't currently on sick leave at the time that the change is being implemented. On the flip side, if you have the contract of employment, which, as I said, sets out the specific entitlement to 26 weeks or whatever it is, then strictly speaking, that contractual entitlement can't be varied without the consent of the employee. But obviously, look, we're in unprecedented circumstances, so employees mightn't be overly concerned with the reduction in their sick pay entitlement, particularly where the alternative is a reduction in workforce.
Okay. And Avril, we have a number of redundancy questions, but one of the questions is when you're picking, you've touched upon selection, and one person has asked, can you still use last in, first out as a selection kind of criteria, or is it just simply considered discriminatory based off age?
Okay, traditionally, last in first out, or LIFO as it's known, was the criteria that was used by employers in selecting an employee against another, and it obviously means that the person with the least service would be made redundant. It's less common these days though, and it doesn't mean it's not discriminatory. You know, all things being equal, and if there's no objective criteria to select between one employee and another, well then an employer can resort to LIFO, but it doesn't always yield the desired results. So employers tend not to use it, and they, you know, will tend to look at things like qualifications, skills, training, technical competence, experience, or, you know, future needs of the business and things like that.
Okay, and last one for you, Orla, as time is where an employee who I assume for the question is fit for work, but they're just refusing or have no underlying condition, and they're refusing to come to work, should that employer invoke their disciplinary proceedings or disciplinary procedure when they're going to deal with them?
I think that would depend on the reason the individual is not coming to work. So first of all, you'd have to sit down and engage with them to see what the reason is. But if it's a case of like, I simply just don't want to come to work, I just want to work from home, well then of course you can engage the disciplinary procedure. Because that is an entitlement, you know, it's your entitlement, it's a requirement of the job to attend work, but you would have to see first of all the reason behind the refusal to come back to work. And just be careful, obviously, if it's in any way associated with the vulnerability or anything like that, just be careful. But it is something that is open to you, absolutely.
Unfortunately, we won't have time to go through the questions that are submitted, but we will respond to people, and I thank people for putting in their names. I can see them here that we can deal with, and there's some very interesting questions, particularly about coming back into work and redundancy and selection and things like that. I'd like to thank Orla and Avril for their time and insights this morning. I also like to thank people for joining. Following this, you'll get a copy of our slides and a copy of a SurveyMonkey questionnaire. I would encourage and ask people to fill it out, because you can dictate the topics that we will deal with the next time. And as you can see, the topics are very fluid and moving. It'll be interesting whether or not whether schools and sick pay will be the dominant thing by the time December comes along. I know in my house, we're very worried that Santi might get COVID-19 and out of action. So hopefully he's on a vaccine trial. But finally, I'd like to thank our marketing team, in particular Sinead, for our patience and helping us with it, and wish everyone good health going forward. Thank you. Bye.